The open meeting for the Federal Election Commission for Thursday, June 7th is now in order. Good morning, everybody. We have a pretty short agenda for the day. We'll get started with the correction and approval of the minutes. Madam Vice Chair, do you have a motion?
I do. Thank you, Madam Chair. I move approval of the minutes of the open meeting of Thursday, May 10th, 2018, as set forth in agenda document number 18-29-A.
Thank you. All those in favor?
Aye.
Aye. The motion passes unanimously. Thank you. Next matter on the agenda, Audit Division Recommendation Memorandum on Kelly for Congress, A17-05. Have the audit team joining us this morning, Mr. Hintermister, Ms. Nerthen, and Ms. Markham. I don't know, whoever wants to give the presentation, proceed. When you're
Good
ready.
morning, Madam Chair and
morning.
Commissioners. Before you is the Audit Division Recommendation Memorandum on Kelly for Congress and recommending approval of two findings. The two findings presented are Finding 1, receipt of a parent prohibited contribution bank loan. Finding 2, receipt of contributions that exceed limits. We're available to answer any questions.
Is there anything from the Office of General Counsel? No? No, okay. Thank you. Commissioner Peterson?
Thank you, Madam Chair. I'm prepared to support finding 2, which is the receipt of contributions that exceed the limits. On finding 1, so this deals with the bank loan. And when reviewing our regulation, the way our regulation works is that a loan from a bank is not a contribution under certain circumstances, provided that it's made in the ordinary course of business. And one of the factors for whether or not a loan is made in the ordinary course of business is whether it is, as it says here, is made on a basis that assures repayment. And our regulation states grounds on which a loan is made on a basis that assures repayment. One of them is if the lending institution perfects a security interest in collateral owned by the candidate or by a political committee, or if the lending institution obtains a written agreement whereby I'll just read the reg, whereby the candidate or political committee receiving the loan has pledged future receipts such as public financing payments, contributions, or interest income. Now, I'll grant that that the loan at issue doesn't meet either of those conditions. However, there's also a kind of a third catch-all provision, a totality of the circumstances provision, that says if the requirements set forth in this paragraph are not met, the Commission will consider the totality of the circumstances on a case-by-case basis in determining whether a loan was made on a basis that assures repayment. As I look at this, the facts of the loan, and if I've got the facts wrong, please correct me. There was a written agreement between the candidate and the bank, in this case, which was what, the First American National Bank. The interest rate, I don't think that we quibble with the interest rate that was at issue here. What I think the issue is the collateral that was put up to secure the loan was not owned by the candidate himself. It was owned by a third party. And I think that that's a relevant consideration with respect to the finding 2, because the same regulation also says that endorsers or guarantors who guarantee a portion of a loan that exceeds the contribution limit, that excess is considered an excessive contribution. But with respect to the bank itself, our consideration is, was the loan issued on a basis that reassured repayment? And as I look at it, it looks like it does, that there was collateral that whose value was in excess of the value of the loan that was given out, that there was a written agreement, and there was an individual involved. Again, what doesn't necessarily create a problem in one circumstance creates a problem in another circumstance because the individual who was receiving the loan was not putting up the collateral, but a third party was putting up the collateral, that raises the excessive contribution issue. But from the way I look at it, it looks like that the bank issued this loan on a basis that assured repayment. So I just wanted to get, I don't know if I turn to the auditors or Office of General Counsel. I realize that this regulation was obviously crafted in a way that in essence acknowledges that we don't know every which way in which a loan can be made that would assure repayment. And I think our explanation and justification for this loan spells that out. It says it leaves open the possibility that other approaches, such as loans guaranteed in part or in whole by the borrower's signature, which are not specified in the rules, will also be found to have met the standard in specific cases. So that's the way I'm looking at this one. It does appear that this was made, from the bank's perspective, that this was made on a basis that assures repayment. But I just wanted to get the feedback from auditors or Office of General Counsel if I'm misunderstanding any particulars regarding the facts that presented themselves in this matter.
Yes, Office of General Counsel has a Thank you. With respect to made on the basis that assures repayment, the two issues that we have with this is that the collateral, there was collateral here, but the collateral was not owned by the candidate or committee. And the regulations 100.82 actually specifically requires that it be owned by the candidate or committee. But it also talks about even with the collateral, it has to be perfected. And this collateral was not perfected. While you have a security agreement, there was no filing with respect to this collateral. With respect to, there was a guarantor here. And when you look at the guarantor, the law says that the regulation is very specific, that the guarantor cannot exceed their contribution limit. And in this case, they exceeded their contribution limit.
And that's the finding two issue.
That is that's with respect to the bank, made on the basis that assures repayment.
Can I just add, I mean, I think from our, oh, thank you. Sorry, I keep forgetting the button. I think we agree and recognize that the totality of the circumstances is a sort of undefined standard that gives the commission some discretion to consider the totality of the specific factual circumstances. In our view, because this particular loan did rely on collateral, the most directly applicable regulation appeared to us to be the one that talks about the requirements that apply to the use of collateral, and using the totality of the circumstances exception to conclude that the collateral was sufficient when there's a specific reg that talks about how the fact that the collateral has to have been owned by the candidate would essentially seem to sort of negate that requirement. And that was the reason that, in our view, it wasn't appropriate to rely on totality of the circumstances, or why we didn't do it. It doesn't mean the commission can, reach a different conclusion based on the factual circumstances. But here, where there was collateral that was used, the regs specifically talk about collateral has to be owned by the candidate, and it wasn't in this particular case.
I'll
She has a follow-up.
yield for a question. I have a further question, but
Well, either way,
yeah.
Okay, I think he's still,
No, that's okay. I'd be happy to yield.
we're all being polite. The point that I would make is I hear what you're saying, that it seems like the bank would be in a different situation. But the issue that I see is that if the collateral could not actually legally be provided because it would constitute an excessive campaign contribution, was the bank actually assured of repayment?
why are those related?
To me, just looking at the loan itself, it seems like, you had collateral that was, whose value was in excess of the amount of the loan that was issued. I don't think that we've, unless OGC can correct me, that the loan was otherwise issued contrary to the applicable banking laws of either the state or
No,
federal
I
banking
understand
laws.
the vice chair to be talking about the FICA requirements rather than banking laws.
Yeah.
But we're not aware of any other banking legal issues under banking laws that.
Can I ask a follow-up?
Oh, sure.
I just wanted to ask a follow-up from what Ms. Klopak said a minute ago. The analysis that you just set forth. I don't believe that's in the audit report or the memo that we received before. I didn't see anything in the E and J that says that the provision that we're talking about, which we're calling the totality of circumstances, sets forth any kind of standard that says, but we're not going to consider collateral if it was put up by someone else. It doesn't get into that.
No, we're talking about 100.82, which sets forth the requirements for collateral,
Right.
which says, the lending institution making the loan has perfected a security interest in collateral owned by the candidate or political committee receiving the loan. So
Wait, I'm sorry,
my response was just to say that,
Wait, which subsection were you reading?
sorry, that's 100.82E11.
Oh, right.
So that section directly addresses the circumstance where a loan is purportedly secured by collateral. And given that that's what the circumstances of this loan were purported to be, that was the regulation that we believed was most directly applicable to the circumstances.
Right, but the catch-all provision says, as you know, under section 100.82, make sure I say it right, E
3, I think,
Three.
right?
says, if the requirements set forth in this paragraph, including the one that you just referred to, are not met, the commission will consider the totality of the circumstances on a case-by-case basis in determining whether a loan was made on a basis that assures repayment.
Correct.
So
And we
what-
don't disagree that the commission has the discretion to do that and reach
Okay.
the conclusion that it was. We're just saying that our analysis, based on the fact that the bank is relying on the fact that it was secured by collateral, it seemed to us that there weren't other it seemed to us that the most directly applicable provision was E11. And the commission obviously has a discretion
Well,
to.
I agree with you that it's the most directly applicable, but there is specifically a totality of circumstances test that says regardless of that one being applicable, you will consider this other one.
Right.
And I just don't think that, at least in the audit report, I don't see any analysis of that totality of circumstances. It just says on page 6 of the audit report, it mentions the totality of circumstance on the second paragraph of subsection C, and then, talks about the things that you were just talking about, and then says, as such, the audit staff concludes that the totality of circumstances do not indicate that the loan was made on the basis that assured repayment. So I think the analysis is not full. Did you have a follow-up?
Yeah, I was just going to point out that I understand the direction from which you're approaching this. I'm approaching it from a slightly different one. The way I view this particular subsection is I believe that the security interest provision, the written agreement with respect to future receipts, I almost view those as, I don't know if it's the best analogy, but almost as safe harbors. If you meet those, then you've complied with the regulatory provision. If you don't meet all of those, then the commission considers whether or not, under the totality of the circumstances, a loan was made on a basis that assured repayment. I don't view it as that if there's collateral involved, then it necessarily goes into E1. But that's my approach on this. And to the point that the vice chair made, I view the bank as they're in the business of making loans and assuring that there's repayment of those loans. And the concern that I've always thought that this regulation addressed is to make sure that the bank is not giving a loan that has either no security interest, nothing that assures repayment, so that the likelihood may be high that the bank will have given a significant amount of money for free, in essence, to a candidate. And in this case, that's not the case. I think that the bank gave a loan that assured that it would be repaid. I don't think FICA places an additional obligation on them. But in this case, as has been in the case in other matters, I'm I know that there have been at least a few other matters. One that I'm looking at right now is MER 5262, Tim Ryan for Congress, which involved, I believe, a $50,000 loan with a cosigner that wasn't known at the time. There was some speculation about the cosigner, and the commission concluded that that the bank, and this was decided on the basis of the totality of the circumstances provision, that the bank issued a loan that assured repayment, but so we found no reason to believe that the bank violated the law, but then did find reason to believe against the candidate and the co-signer for the making and the receipt of an excessive contribution. So that's the mode in which I'm approaching this, and I can understand how reasonable minds can differ on this. It's for that reason that I'll, like I said, I'm prepared to support the finding number 2, but I will ask that finding 1 be put in the additional issues for the proposed final audit report.
Thank you, Commissioner Peterson. Madam Vice Chair.
Thank you. Could I ask counsel to speak to the distinctions that they see between the Ryan case and the Kelly situation?
Yeah, I mean, I think the totality of the circumstances standard talks about the looking at things on a case-by-case basis. So it's, as a general matter, it doesn't seem to be intended to be a precedent-setting exception, rather than, you look at each case on the specific facts of that case. We did look at that MER, and there were a lot of details about the record in that MER regarding representations by the bank and bank representatives about their understanding that the loan was made on a basis that assures repayment. But we don't disagree that there were similarities between the loans. So, I mean, I've explained why we thought, how we approached this particular loan. I don't think it's a really, I think that it's not unreasonable to reach a different conclusion, as other commissioners have articulated, but I think that our analysis is consistent with what the regulation says. So that's how we approached it.
And if I could ask a follow-up, and I hope I won't be putting you on the spot, but it's a long time since I looked at the commercial code. Can you elaborate on what about this, why the security interest wasn't perfected?
Yes, what they were required to do under, I think it's Article 9, is that they would actually have to file with the local jurisdiction to perfect the security interest. And my understanding from the auditors, they did not. In fact, they didn't initially receive the title to the collateral. Is that correct?
Correct.
Yes.
With respect to the question about whether it was perfected, and I know Lorenzo really wanted to say that because it was his favorite class in law school. So good job on that. But I don't think it's required, at least under the totality of circumstances test. I mean, it is for the provision that's more related, but again, the totality of circumstance provision says regardless of whether it's met over there, the commission will consider the totality. So there's nothing in the totality part that says, and by the way, when you're determining this, the collateral should be perfected. Madam Vice Chair.
Thank you. Yeah, but the overall provision, even under the totality of the circumstances test, it still has to be, the loan still has to be made in a manner that assures repayment. So I think given that they did not perfect their interest in the collateral, and also given that the argument could be made, at the end of the day, the guy could have turned around and said, oh, wait a minute, that's, I can't actually do that because that would put me in violation of another law, which I think would be, which is the FICA, which I think would be problematic. So I'm not convinced that, I hear what you're saying, but I'm not convinced that the bank actually was assured of repayment under these circumstances. So at the appropriate time, I will move approval of all the recommendations.
I hear what you're saying, and I realize we have a different approach to looking at the totality of circumstances. But there's nothing, I mean, if you're the guy out there trying to decide whether to do this, there's nothing in the regulations that says that it should be perfected or that I saw in the totality of circumstances section or in the E&J that I saw. And, even in the campaign guide, which I know doesn't have legal authority or precedent, it talks about methods of assuring repayment, talks about the provisions 1 little I and 2 little I that we've been discussing, and specifically says other methods of assuring repayment, talks about the case by case, cites the reg, and cites an advisory opinion, which is not actually exactly on point. But anyway, it's laid out there for people to let them know that there's this alternate provision and doesn't put any, doesn't cabinet it in either in the reg, the guidebook, or the E&J. Madam Vice Chair.
If not to belabor this excessively, but I think there's a general rule of statutory interpretation that when there's a very specific provision on point, and then there's a more general provision that might apply, that the specific provision governs.
I think that's true, but again, it says if the requirements set forth in this paragraph are not met, so it specifically contemplates that you don't meet the other 2 more specific ones. And so therefore, and we're required, it says the commission will consider. So it's not just it doesn't just, the argument that one is closer to what happened than the other doesn't, in my opinion, fly here because it specifically says even if you meet the other one, you still have to look at the totality.
If I
Sure.
may, Madam Chair, I think the way I would interpret that is that there may be other circumstances not contemplated by the regulation, and that's why you have this fallback totality of the circumstances provision, that if there's something that we didn't think of when we were writing this regulation, which was written before any of us were here, then, there's a catch-all that one could rely on. But this kind of situation was clearly contemplated by the drafters of the regulation. So I think from my own view is that the better interpretation is the one that OGC is recommending.
Well, and as Peterson points out, there's a couple of MERS, they're very close on, they're not 100% on point, but they're close, that they came to a different conclusion than yours. I'm just pointing it out. Any other comments? Audit, do you have any? No. Commissioner Peterson? Oh, sorry, Steve, did you?
Walther.
Commissioner Walther?
I do have some questions that I guess concern me about the perfection, because if they didn't perfect the loan, and it's clear that they did not, which I wasn't that sure until I started looking at it a little closer this morning, what we're really doing, if we are talking about the totality of the circumstances, is approving an unsecured loan. Because I don't see anything here that assures that the bank has the authority like they normally would get the driver, they'd get the certificate of ownership, and they would sign it and hand it over to you. And that's, the bank has that security, that's fine. Without taking that step, the bank is making an unsecured loan. I'm surprised they did that, but I guess there must have been a good relationship of some kind.
Actually, they didn't have a relationship with these people.
Well, apparently they made a loan, but it's really an unsecured loan, so that we would, looking in the future as to precedent, I think we'd be looking at, the totality included giving an unsecured loan. And all the business about the security and security is not secured. So that's the concern that I have, is kind of the future. I mean, it all came out fine, the money was paid, and no harm, no foul, but the precedent is great. Just the way I look at it.
Commissioner Peterson?
I don't know how we want to sequence. I don't know if the vice chair might want to make a global motion as to all the findings, and then I'd be happy to make a motion as to finding 2, and that finding one be placed in additional issues. So I'd be happy to.
Just do them one by one, maybe.
Well, I think that was what I was anticipating.
Okay.
So with that, and the only, just make one small further point in support of what Commissioner Walther just said, is I believe, and staff will correct me if I'm wrong, that in the earlier case, in the Ryan case, there was an ongoing banking relationship with those individuals, and in this case, there wasn't. And sometimes banks will, for their existing customers, do something that they might not otherwise do because they have money in the bank. So, with having said that, wait. Well, I'm not sure.
Can I draw to their attention?
Sure.
This was a document that was provided me by Cindy and somebody or other who was vice president of the bank. And it said, since Mr. Bowen has had a banking relationship with First National Bank, I told him he could bring them in by the following week. When they came in to sign out, they forgot to bring the titles with them. There was a plan to bring the titles, apparently. Since he had a banking relationship with First Amendment, we went ahead and did it anyway. Loan is paid off on June 5th. So, I don't know where this letter came from. It said since they had a banking relationship, they didn't require them to bring the title in right away.
The guarantor had a relationship with the bank.
Oh, but the candidate didn't. Okay.
The guarantor,
guarantor.
not the candidate, but
Right,
the
the
guarantor.
candidate and the committee did
Had no
not have the
banking
relationship.
relationship.
The guarantor had it. Got it. Thank you.
Guess that's you.
Should I go to motions?
Oh, sure.
Thank you, Madam Chair. I move approval of the Audit Division recommendations as set forth in the Audit Division Recommendation Memorandum on Kelly for Congress, A17-05, Agenda Document Number 18-30-A.
Thank you. All those in favor?
Aye.
Aye.
Opposed?
No.
No. The motion fails by a vote of 2-2. The Vice Chair and Commissioner Walther voting in favor, Commissioner Peterson and I voting against. Is there another motion? Commissioner Peterson.
Thank you, Madam Chair. In Audit A17-05, with respect to the Audit Division Recommendation Memorandum on Kelly for Congress, I move that we approve finding 2 and that finding 1 be placed in additional issues.
Thank you. All those in favor?
Aye.
Aye.
Motion passes unanimously. Thank you very much. Do you need anything else from us on this? We're good. Okay, thank you. The next matter on the agenda is the approval of the rest of the meeting dates for this calendar year, July through December. There a motion?
There is, Madam Chair. I move approval of the calendar as set forth in Agenda Document Number 18-31-A.
Thank you very much. All those in favor?
Aye.
Aye. The motion passes unanimously. Thank you. Mr. Palmer, are there any other management or administrative matters we should discuss at this time? Thank you. This meeting is adjourned. Thanks.